So what is a constitution? Let's find out. Okay, here's a very rough definition of what a constitution is. It's a body of rules that establishes the main institutions of government and regulates how they operate vis-à-vis each other and also in relation to us, subjects. Almost all countries in the world have a written document called the Constitution, which contains these sorts of rules, establishing the main institutions of government and regulating how they operate. A famous example, of course, is the Constitution of the United States. And the first part of that document establishes the main institutions of the US government. Article 1 concerns the legislature and provides for the establishment and functioning of the US Congress. Article 2 concerns the executive branch, focusing on the US president. And Article 3 concerns the judicial branch, focusing on the court structure and in particular the US Supreme Court. In addition, there are other parts of the US Constitution that regulate how those main institutions of government operate in relation to subjects, the governed. So for instance, the First Amendment to the US Constitution concerns freedom of expression. And essentially, it disables the US Congress from making legislation that would interfere with your individual right to express yourself freely. So these sorts of rules establishing the main institutions of government and regulating how they operate can be found in constitutions across the world. That being said, while you do have those similarities, constitutional texts can differ very greatly. One very noticeable difference is, of course, the length of the constitutional text, how much content there is in the document. For instance, the US Constitution, which came into effect in 1789, consisted at that time of only 7 articles, and to modernize that might look rather minimalist. It has since been amended 27 times, and at this point the total word count is around 8,000 words. But the word counts of constitutions can vary very significantly. So the US Constitution around 8,000 words, Japan's Constitution, which has never been amended, around 5,000 words. These are all relatively short constitutions, and then you have some much longer constitutions. South Africa, its constitution is around 43,000 words. The Constitution of India, its constitution is around or approaching 150,000 words. All this raises a whole series of interesting questions about the content of constitutional texts. What should go in the document? For instance, the South African Constitution, which was promulgated in 1996, contains rights concerning the environment, a right to adequate housing, a right to health care, a right to receive an education. These rights are protected under the South African Constitution, but are not protected under many other constitutions around the world. And there's a vibrant debate about what should go in a constitutional document. One of the other features here, of course, is the more you have within a constitutional text, the longer it gets. So the South African Constitution is around 43,000 words when compared to the US Constitution around 8,000 words. That is not necessarily cost-free. The longer a constitutional text becomes, perhaps the more difficult it is for the public to understand it, to engage with it, and the sense of public ownership of the Constitution may be reduced as a consequence. In the case of the US Constitution, which is relatively short, people sometimes speak of how you can purchase a copy of the Constitution as a little book and just pop it into your pocket. And there's that sense of ownership, of public ownership of the Constitution that's possible with a shorter constitution that may not be with a much longer constitution. There is one further point to make here about the content of constitutional documents. While it is the case that a constitutional text will contain important rules concerning the main institutions of government and how they operate, equally, some of the rules within the constitutional document can be rather mundane. Under the Indian Constitution, for example, Article 195 concerns the salaries of legislators, and that's hardly in the same league as rights on freedom of expression or freedom from torture. There is another big issue that I just want to touch on, and that concerns amending, changing constitutional documents. Constitutions typically contain rules concerning whether and how they can be amended, And once again, there is considerable variation across the different constitutions around the world. One big underlying question here is how easy or difficult should it be for a constitutional document to be amended? And there are different views. One view might be that constitutions shouldn't be too difficult to amend, that constitutions should be flexible to some degree so that they can be updated and modernized in light of present circumstances. Another view might be a bit more doubtful and think, well, constitutions should be long-lasting, and that amendments, frequent amendments to constitutions, actually is a sign that those constitutions aren't working well, and that's why they have to keep being revised. In practice, some constitutions have been amended more frequently, and others much less so. Japan's constitution, which was adopted in 1947, has never been amended, although there have been some attempts to try to do so. It's also worth noting that there are some constitutional documents which contain what are known as eternity clauses, so provisions of the constitution which cannot be amended. One example is the German constitution. Article 79 of the German Basic Law lists certain provisions of the German constitution which cannot be amended. The same is also true of the Greek constitution under Article 110 of that constitution. All of this, of course, connects to the wider debate about amendability. How amendable should constitutional documents be? Okay, let's take a breath. So we've had an overview of constitutional documents, these constitutional texts that appear in almost all legal systems around the world. Great. But all that being said, it's not the case that all the rules of the Constitution appear in these documents. Most constitutional rules, in other words, rules regulating how the institutions of government operate vis-à-vis each other and in relation to us, the subjects, most of these rules will exist outside the constitutional documents. If we take, for instance, the First Amendment to the US Constitution, Congress shall make no law abridging, limiting freedom of speech. If you were to read that in isolation, you might think, well, there can be no federal legislation in the United States that in any way limits what people can say. In fact, that's not the case. And for instance, there is federal legislation concerning the protection of official secrets, classified information, and so on. There is legislation that criminalizes the disclosure of these sorts of secrets, this sort of information. One example of this sort of legislation is the US Espionage Act of 1917, still in force and has been upheld as being constitutional by the US courts and has been used to charge individuals who have disclosed government information, government secrets, most recently figures such as Edward Snowden and Julian Assange. So in other words, in order to fully grasp how the First Amendment is operating, you can't simply look at the words of the constitutional document itself. You have to look at some of the case law, you have to look at some of the relevant legislation in this area. And this is true of other constitutions around the world as well. Okay, another deep breath. So, thus far, we've been focusing on what a constitution is and how it's operating. And we've been thinking about the constitutional text. We've also been thinking about other constitutional rules that aren't within the constitutional text, but also are relevant to how the constitution is operating, how the main institutions of government are operating vis-à-vis each other and in relation to us as subjects. All of the rules that we've talked about thus far are legal rules. There is one further body of rules that's relevant here, non-legal rules that are also constitutional rules. Why? Because they regulate how the main institutions of government operate. For instance, if we stick with the example of the US president maintains a cabinet. Now, the rules by which the cabinet operates, those are not to be found within the US Constitution, the constitutional text itself, nor are those rules set down in US federal legislation or in case law. Instead, these rules are non-legal rules that have emerged over a period of time and regulate how the US cabinet operates and its duties and responsibilities to the US president. Again, these are constitutional rules because these are rules concerning the operation of the main institutions of government, in this case, the executive branch. This is no different at base from many other organizations where rules emerge, social rules, customary rules concerning the behavior of important elements within that organization. So to sum up, what is a constitution? Well, it's a mixture of things. There are legal rules to be found in the constitutional text and also in relevant legislation and case law. Equally, there are non-legal rules that are also constitutional rules because they go to the functioning of the main organs and institutions of government as well. There are other big questions here that I think can be explored in future videos. Does the UK have a constitution? Because the UK lacks a single document called the UK Constitution. How do we measure the success of constitutions? What are the criteria, the metrics of success, and how do we test them against the evidence? But anyway, these are potentially topics for future videos. Thanks very much for listening, guys, and take care.